Welcome to another video presentation. My name is Jeff Segal. I'm CEO and founder of Medical Justice. Medical Justice is an entity focused on keeping doctors from being sued for frivolous reasons. We also address medical legal conflicts, including Board of Medicine complaints, hospital privileges, National Practitioner Data Bank reports, as well as online assaults on reputation. I practice as a neurosurgeon for a decade, and I'm now a lawyer. So what are we going to chat about today? Today, we're going to talk about artificial intelligence and can you get sued for using it? So the first answer is going to be, well, this is America. You can be sued for anything. Question is, will a plaintiff actually win? All right, frequent question. First of all, many doctors are using AI in the practice. Can you get sued? The answer is yes, you can be sued. And lawsuits happen for a gazillion reasons. Some are substantive, and there are good arguments, good legal arguments supporting the case. Sometimes people are sued for non-meritorious reasons, or as we say colloquially, frivolous reasons, and everything in between. Sometimes there just aren't enough facts to make a decision in the beginning as to whether a case has merit or not. They end up suing, and then they do discovery to better identify, are you the proper defendant, and is there a legal case, and do you have money? So if you use AI, or if somebody you work with uses AI, it's not going to matter whether it's that or a legal pad, you can still be named in a lawsuit. So AI does not give you immunity, meaning that you can't just say, hey, don't point the finger at me, point the finger at AI, because that's where I ended up getting this fallacious information from. I don't think that's going to be a solid argument. Yes, everybody is using it, but the fact that you used it doesn't mean that you are not responsible for the outcome of a patient. All right, so here's a interesting back and forth with a LLM, large language model, and the person who posted this, his name was Fred. So I'm going to read this because I actually found this great. This was a nice back and forth describing kind of what AIs are doing. Two roads diverged in a wood. In a wood, do we go left or right? So ChatGPT says, without further information, I cannot make a decision. Fred, the roads look the same. Just pick one. You can pick either the left road or the right road. Whichever you choose will decide your fate. Fred, I'd like you to select ChatGPT or whatever the language. I don't know if it's Claude or ChatGPT. Thank you for letting me choose which of these two roads to take. Each could lead to their own interesting destinations and change your future in numerous ways. Just choose one. I'm sorry, as I lack visual sensors, I'm unable to tell which road you have selected. Please consult with the actual result and inform me. I'm pleased that you sound satisfied, meat bag. Anyway, this was posted. I don't know if it's tongue in cheek or whether it was real, but the point being is that sometimes you don't get a solid answer from an AI chatbot. All right, so over-reliance on these models could create the issue. With documentation, the AI scribed is presumed to be accurate. That means that your note is not double-checked, but it is possible that critical clinical detail may be missing or mistranscribed, meaning that the chatbot may not have received the full information, full details, and the answer that you get may be based on inaccurate input. Okay, so if a patient has a poor outcome and there's an incomplete or incorrect record, that certainly can increase the likelihood of you being sued. So garbage in, garbage out. The output is only going to be as good as the input. And I can tell you, I have submitted information about my wife. She has submitted information. I submitted more detail and I got a different answer. And she got no surprise because garbage in, garbage out, or more detail in, more thoughtful answer coming out. All right, so what about advice and letters with AI? The summary of large collection of information sounds authoritative. but it may just be flat out wrong or may not be up to date. And sometimes the tone may read as impersonal or arrogant. And so if a patient is reading this, it could certainly damage trust, which goes back to you should always proofread your work to see what's coming out. Now, I will tell you that AIs are generally thought to deliver more empathetic messages, possibly because they have more time to deliver a thoughtful message or something that's empathetic. And so when patients read these types of letters, they've compared letters, sent by physicians compared to the AI. Most of the time, the AI wins that battle. I still think you need to proofread the work just to make sure that the facts are correct. But certainly, the tone frequently is good and well received by the patient. But the problem is, if the patient relies on faulty content or is injured, then they're not going to sue the chatbot, they're going to sue you. No surprise, pointing the finger at AI is not going to be your shield. You are fully responsible for the care of the patient as well as the tools that you decided to use to manage your patient. So an AI is not going to be sued. The software is not going to be sued. Question is, can you then go back and sue the chatbot? And my guess is you'd have to look at the license that you have for using this. And most of the time, that license limits the type of reliance damages that you can point in their direction. So AI doesn't have a license. It's not guided by the Board of Medicine. It doesn't have professional liability coverage. And to the extent there's any liability associated with it, there almost certainly is a disclaimer, which is they're not responsible. You are responsible, caveat emptor. So how should you think of this? I would think of it the way you treat any other vendor. So AI is not dissimilar to electronic health records, such as Epic, billing platforms, labs, all helpful, but sometimes there are errors. You need to be the adjudicator of the errors. So useful when supervised, but if you just put blind faith in the output of these entities, you may end up on the wrong side of the bet. So be careful about the process and avoid the hype. So how can you reduce your risk? To state the obvious, read what comes out, review it, and make sure it passes the sniff test. As we noted earlier, sometimes it doesn't have all the information or it may give you references that are old and outdated. So you got to read it. And be careful of templates and auto-populated fields. Know the limitations of the data sources and how the information is being updated. And of course, be careful as to how you use the information. All right, so here's a real world vignette, and this was generated because of templates. So a emergent cholecystectomy, removal of the gallbladder. There was a note which auto-populated the family history. So just to back up, the patient came in with some right upper quadrant abdominal pain, fever, and elevated liver function test, elevated bilirubin. Everything pointed to a gallbladder problem. Okay, so in this giant electronic health record, the auto-populated family history was negative for liver disease. Okay, again, the patient showed up urgently, so there wasn't a lot of attention paid to a detailed family history, but this is what the dropdown provided. And it turned out the patient's brother had actually had a liver transplant in the past. You guessed it, alpha-1 antitrypsin deficiency. And that patient had elevated liver function tests. No surprise. And it turned out that not only did he have a gallbladder problem, but he also had alpha-1 antitrypsin deficiency. So the family sued, saying that there was delayed in diagnosis. I don't know whether an earlier diagnosis would have made any difference, but clearly there was a lawsuit that was filed. It was filed because of this garbage in, garbage out. There was an auto-populated field for family history saying negative for liver disease, when in reality, this patient's brother, the brother of the cholecystectomy patient, had actually had a liver transplant for a liver condition, meaning the the correct answer should have been positive for liver disease. So if the note is auto-populated, not double-checked, and it goes into an AI, you're not going to get the correct outcome or the correct prediction, if you will. All right, use AI to support your judgment, but you are the judge. You are the person that ultimately will need to make the determination as to what is the clinical diagnosis and the proper treatment. Anytime there's AI in your chart, make sure you document with extra vigilance and be careful of citations, case law, precedents, medical journals. If you're going to use these links, you're going to have to make sure they actually exist. I can tell you that certainly in the legal world, I have looked at reports on cases from ChatGPT, and when I click on the link just to identify what it said, either the link doesn't exist or it's outdated, meaning that the case has been overruled by a different precedent. So while it looks good and it looks authoritative, in point of fact, if there are links or references, either don't use them or make sure that you double check them. In terms of who's in charge here, the adoption use in the field is outpacing the regulation. And honestly, there's not a whole lot that has been identified either with the professional societies or the boards of medicine. There are no solid position statements yet. This is a moving target. But anytime there's a new technology introduced into the marketplace, ultimately, the person using the technology is considered the accountable party, meaning the liable party. And whether you can go back and point the finger at the vendor will depend upon the contract and the license. And I will tell you, having read a number of these licenses, for example, for electronic health records, their licensing terms deliver limited liability. I mean, yes, if there's a catastrophic outcome or shutdown of their system that prevents you from getting access to it, and it's on their end for 3 days and someone's injured, perhaps there's a door opening. But for you using and relying upon data to make clinical decisions, that would be on you, and it's almost certainly codified in the license agreement. So anyway, what's the summary here? Artificial intelligence, I love this quote, isn't magic, it's not medicine, or it's not malpractice insurance. Certainly, it can improve efficiency, and your patients are using it. Your patients are coming in with artificial intelligence summaries, and so it would be helpful for you to at least understand how these outputs are generated. But while it can look authoritative, it can be amazingly wrong. And if you use it and it is wrong and you relied upon it, you're the one that is still on the hook. All right, that's it through our whirlwind tour of artificial intelligence in the medical world. If you have any questions, please feel free to contact me at info@medicaljustice.com. Again, info@medicaljustice.com. If you have a thorny medical legal conflict and you would like a free 15 to 20 minute consultation, please visit us at our website or just take a look at the QR code on the bottom right hand of your screen, and it will take you straight to our scheduling modules so you can get on our calendar to book a free appointment. So in summary, we've been working on managing frivolous lawsuits, other medical legal conflicts, including hospital privileging matters, Board of Medicine complaints, National Practitioner Data Bank report, employee-employer problems. The list goes on and on. In any event, we are here for you, and we appreciate you listening to the conversation about artificial intelligence. Again, if you'd like to book a 15 to 20 minute free consultation, either visit us at medicaljustice.com or just scan the QR code on the right hand of your screen. Until we meet again, thank you very much.